someone who has done an incredible job in terms of his scholarship on this era in American history and this question specifically is Logan Stagg East. He's an independent historian in Louisiana, and his work has dealt extensively with the nature of constitutional politics during the Gilded Age and the progressive era. And he said in an article, which I shared on my Facebook page at facebook.com/Morano fan, 9,000 times more articulately and far better research than I could ever hope to be. Pretty much what I wished I was smart enough to say. I had him on last week, and the response to this discussion was phenomenal. A lot of people writing in disagreeing with my approach and with Theodore Roosevelt's approach, and a lot of people saying, I'm interested. I want to learn more. I want to learn more. So we've invited him back for a full hour, and we'll do our best to answer your questions as well at 800-848-9222. Logan Stagg East, thanks so much for joining me on the radio again.
Hi, Frank. Thanks for having me back.
All right. So I guess the one of the fundamental things that we hear about the Supreme Court, and I'm curious about your view on this question, is that they are a co-equal branch of government. And the fact that the legislature can make laws and the executive can enforce laws and the courts can interpret the laws, that creates a nice equilibrium that keeps any branch from getting too powerful. It's a separation of powers. But there really isn't anything in the Constitution that I see that says they are a co-equal branch of government. What is your take on the concept of the court being a co-equal branch of government and the idea of separation of powers in general?
That's a great question. And as far as how the founders viewed it whenever they wrote the document, I would argue that a lot of them really thought that the primary branch of government was the legislature. Whenever we look at it today, of course, I think most people probably look at the executive branch, the presidency, as the leading role, and that's not really what was intended at the time. But that said, the court, I think, does serve a very important role, and it is a necessary role. Whether it's equal or not is hard to say. I would say no, it's not quite equal, but its role as interpreter is important. The question really is, okay, what are the limits of that interpretive power? What is its just application?
Well, let's talk about the limits of that interpretive power. There have been so many cases over the years that liberals and conservatives have been upset with. Conservatives were not at all happy with Roe versus Wade. Liberals were not at all happy with the Citizens United decision. Conservatives were not at all happy with the decision on gay marriage. Liberals were not at all happy with the gun case, the Heller case. It seems like both sides, conservatives and liberals, were very upset over the eminent domain case in the Keogh decision. Why don't more modern politicians, political figures, think tanks, members of Congress seek to bring out more Theodore Roosevelt-style solutions and push for a popular constitution rather than just continue to accept this rule by judicial fiat?
That's a great question. And part of the problem is that whenever you make an attack against the Supreme Court, and I want to be careful with, we don't want to slip into demagoguery. We don't want to, because the judges do serve a necessary role of some kind, and we want to get into that throughout this hour. But there is a perception that when you attack the court, you're attacking our entire constitutional order, because most Americans believe that there should be some limits on what popular government can do. We can't just make up the rules as we go. Otherwise, we can fall into tyranny. And the judges, they're draped in serious black robes. There's a reason for that. And to attack their decision seems to be like, okay, well, you just want to change the rules now that you didn't get what you want. And sometimes that is what is happening. The last time a politician really tried to tinker with the Supreme Court famously is Franklin Roosevelt's court packing scheme. Now, he wasn't doing what I think is a reasonable thing to do, but it looked like he was upset with the rulings of the judges, which, judges seem to be good people, interpret the Constitution. And so it seems as if you're attacking the constitutional order. And most people don't have the time to spend to really get into the details to see why that's not always accurate.
Now, you mentioned Franklin Delano Roosevelt and his plan to pack the court, the conventional narrative, and you can correct any areas that have been misinterpreted by historians over the last 80 years. But the conventional narrative is that the court was striking down a lot of New Deal legislation that was very important to President Roosevelt, and he proposed this plan to pack the court and allow himself to appoint a justice for every justice that was over a certain age, which would allow him to have a lot more appointments, presumably appointments that would not then nullify these pet legislative projects of his. And then the court kind of they got intimidated into not nullifying the laws that were passed by Congress and signed by the president. In your view, did Theodore Roosevelt's candidacy and his attacks on the court and their nullification of certain decisions regarding business interests and so forth, did that pave the way for his cousin Franklin's attack on the court 20, 30 years later?
Yes and no, in that both Roosevelts believed that the way that the court was interpreting the Constitution was out of touch with where both common understandings of the law were. And I don't have the quotes from Franklin, but the quotes from Roosevelt, he believed that the court was out of line with how even older Americans like Lincoln or Washington would have viewed the Constitution. In the case of Franklin Roosevelt, though, and both of them are dealing with what's called the Lochner era, a philosophy behind interpreting the Constitution we can get into if you want. But the threat of possibly tinkering with the Supreme Court is what, as you said, led to the switch in time that saved 9, and that was the West Coast Hotel versus Parish, or Parish versus West Coast Hotel, which upheld a state's right to have a minimum wage. And so actually the threat, even though it cost them a lot of popularity, conservatives take back Congress, resulted in the court kind of bending its way. It's a similar motivation, but Franklin is missing the point. Franklin is threatening to change the composition of the Supreme Court. I want my umpires in there as opposed to the other teams, whereas Teddy Roosevelt was saying, no, the people need a check on the power, not just let's tinker around with the membership of the court.
Interesting, and that is such an important distinction. Franklin accepted the proposition that the court has the ability to nullify laws, and Theodore was challenging that ability, at least aspirationally.
Correct.
Yeah, that's interesting. So you use the phrase judicial supremacy in your piece, and the way a lot of people use the term judicial review. Now, I know you have said you consider yourself a conservative. Why do, not that you can speak for all conservatives, but why do, in your opinion, why do conservatives bow to this doctrine of judicial supremacy? When there's a conservative Congress, a conservative governor, a conservative president, why don't more conservative legislators or politicians do what Andrew Jackson did and ignore what the court decides to do in terms of nullifying a law, for instance?
Well, I think it's because the well of nullification has been poisoned very badly by figures like John C. Calhoun, the Civil War, the Civil Rights Movement, other instances, and that leaves a very powerful negative legacy in that direction, even though it can be used as a broad brush to criticize any attempts to criticize what judges are saying. But I think the conservatives tend to feel a loyalty, which I will admit I feel in my heart as well, to the system that we have, the Constitution as it stands, and believing that, the judiciary is a part of that constitutional plan, and that, we have to honor the procedures and format and not get too rowdy with it. I think that is a 20th century attitude, not a 19th century attitude.
Mm-hmm. Where did the idea of checks and balances as it relates to the court and the legislative branch, where did that come from? Was it just made up out of whole cloth in Marbury, or was there some movement for a check on the legislative passions of the day?
Yeah, no, it's definitely not made up in Marbury. Judicial review is what we get out of Marbury, and we can talk about that. The idea of checks and balances, the division of powers, is an Enlightenment idea. First, sort of,
Montesquieu, right?
yeah, Montesquieu, exactly, the laws. And he said he observed parts of that in the English parliamentary system. But then, whenever we are writing, they write the Constitution at the convention, and there is this great debate over, are they going to ratify the Constitution? And many people at the time, many anti-federalists who opposed the Constitution, said this was going to concentrate far too much power in the federal government, and some of them even criticized the potential court. But James Madison, as well as John Jay and Alexander Hamilton, famously in the Federalist Papers, came up with arguments for why the Constitution was the real deal while it was good. And Madison famously articulated the vision under under Publius as his name, said that the separation of powers, each branch will check the other, and thus we will prevent centralizing tyranny. But the idea of the Supreme Court having that powerful authority comes with Alexander Hamilton, really in Federalist 78, where he doesn't say judicial review, that term doesn't come around till like 1914, but he proposes a power that the magistracy, the court will be able to uphold strong laws against the popular passions and masses. And some anti-federalists said at the time that, they might be able to rule whatever they wanted.
But and I've read Federalist 78 and what Hamilton said there, but what he says, he was very specific. What he says is that they can do that only when there's an irreconcilable variance between what the legislature is doing and what the Constitution says. Now, if 5 justices can view a question one way and 4 view it another way, I mean, that's hardly irreconcilable. But if they wanted to pass a law that said there's 105 senators instead of 100, that's a pretty clear irreconcilable variance. I mean, I have to think that we're light years from where Hamilton viewed the Supreme Court exercising this power.
Oh, I think you're absolutely right. And that basic position, and I'm going to, this is a loaded term, but it's a textualist position. It's saying, okay, because we have to say, well, what is the Constitution? And we're talking about a popular Constitution here. The Constitution was a popular document that was ratified by every state, now, by an electorate that today is sometimes criticized as being too narrow, but for its time was a very broad electorate. And each part of the Constitution was proposed by delegates elected by the states, and then each amendment was passed and ratified by the states. And so what we have in the Constitution is popular law. And what the idea is that law has to be interpreted and enforced. But if a judge begins to make up his own, legislate from the bench, as it's called, that would be illegitimate. And Hamilton said that won't happen. They'll be bound by strict precedents and procedures. But the reality is, someone has to make a judgment call. And under judicial supremacy, we kind of accept that final judgment call as the court.